I will never deny, and the ICC can record it. Those who destroy my country, I will kill you. And those who destroy the young people of our country, I will kill you. Because I love my country. My orders to you, if you see them walking around, kindly shoot them dead. I will be happy. Anyway, you're already charged in the ICC together with me. So what is the problem of adding another one? Another idiot Filipino who has caused great damage to our country. File the case in court because may korte tayo. And even if I will admit na totoo yan, you have to go to court because I will make the admission there again.
Are you saying, Mr. President, that when you go to court, you're willing to admit also your accountability for all the deaths during the war on drugs?
Ay, of course, may abogado man ako, ma'am. Kung ano sabihin ng abogado ko, sunod ako.
I hope that everything that you said before the Quad can be reduced in writing so that truly we can believe that you're taking full legal responsibility to all the victims of war on drugs, both legal and illegal, because as lawyers we believe that by extrajudicial confession, we have to put that in writing, Mr. President.
Totoo yan, ma'am. I order the campaign against drugs. Totoo yan, ma'am. I order the campaign against drugs. Totoo yan, ma'am. I order the campaign against drugs. Hindi ako it's a policy of government or of the president. Hindi ako maghugas ng kamay. Hindi ako magsabi hindi kasi yung department hindi akin yun.
Mr. President, last question. If one of these days the ICC will come, will you voluntarily submit yourself?
Sipain ko pa sila, ma'am. Sipain ko pa sila, ma'am. Sipain ko pa sila, ma'am.
But you said a while ago that if somebody will sponsor your fare to the ICC, you will voluntarily submit yourself to their investigation and jurisdiction.
Yes. Pero kung sila magpunta dito, sipain ko.
But will you confirm that you are willing to submit voluntarily yourself to ICC?
Punta ko doon, sipain ko rin sila. Same.
I have nothing further, Mr. Chair. Thank you, Mr. President.
The arrest of the former president of the Philippines, Mr. Rodrigo Roa Duterte, is an important moment. The office has been investigating the situation of the Philippines for some time in relation to the so-called war on drugs. Last month, under the supervision of Deputy Prosecutor Manjay Niang, the team submitted a warrant application to the judges of the pretrial chamber. The judges have issued that warrant and it's been executed. And in issuing the warrant, the judges have found reasonable grounds to believe that Mr. Duterte has committed the crime of murder as the founder, as the head of the so-called Davao death squad, as the mayor of Davao City, and then later as the president of the Philippines between 2011 and 2019. And I think it's important to show that the office has been working with communities, with states, with international organizations, with other partners to make sure that the investigation could be focused and could move as effectively as possible. And the fact that it's been executed is important to victims. It means a lot, I think, to victims. That's the feedback we've already received. And many say that international law is not as strong as we want, and I agree with that. But as I also repeatedly emphasize, international law is not as weak as some may think. When we come together, when we work, when we build partnerships, the rule of law can prevail, warrants can be executed, and it's important to underline as we now start a new stage of proceedings.
If you talk to lawyers, they call it extraordinary rendition, but for a family member like me, that's kidnapping.
Yeah.
That's forcibly taking my father to another country and illegally arresting him. So that's clearly kidnapping.
Two troubled entities struck an unlikely alliance. An incumbent president who wished to neutralize and choke the legacy of my client and his daughter on the other hand, and a troubled legal institution subject to delegitimization and desperate for a price cuts and a legal show today on the other hand. With this in mind, it is not surprising that my client was abducted from his country. ICC private jets do not drop out of the thin air. That jet which received my client was coordinated in advance. The UAE is not a state party to the ICC and has no obligation to cooperate with the court. Yet my client sat in transit in that country for more than 5 hours. I invite the registry's representative to present today in court to explain to the judges exactly how they believe this transfer was anything other than a gross abuse of process. Given the precipitous arrival of my client, an elderly man with debilitating medical issues, hard of hearing and poor of sight, he was taken to a hospital for observation. Only this morning have I met him for the first time with less than an hour to discuss legal issues. I have not been able to present him with a hard copy of the arrest warrant because we were not supplied with such. I have not even been able to explain to him what the prosecution requested when seeking the issuance of the arrest warrant. This is because the chamber only established a redacted version of the prosecution request last night. Other than to identify himself, my client is not able to contribute anything to this hearing. Most importantly, he is not able even to tell you that he has been informed of the charges as contained in the arrest warrant for a reason more pertinent to which I alluded in my written request to this honorable pretrial chamber this morning, and which is confidential in nature. Accordingly, I repeat my respectful request, which was rejected this morning, to postpone the substantive aspect of this hearing to the next week, when I will have the opportunity to sit with my client and to explain to him what a confirmation hearing is and what the disclosure is and how the prosecution alleges that he committed crimes.
On 7 March 2025, Pre-Trial Chamber 1 concluded that there were reasonable grounds to believe that Mr. DUTERTE is criminally responsible pursuant to Article 25(3)(a) of the Rome Statute as an alleged indirect co-perpetrator for the crime against humanity of murder pursuant to Article 7(1)(a) of the statute as follows. A. Murder of at least 19 persons, allegedly drug pushers or thieves, killed by members of the Davao Death Squad in various locations in or around Davao City, Philippines between 2011 and 2016.
But I don't think it is for any domestic court to order the ICC to release a prisoner already within the jurisdiction of the court. In other words, accused over whose person the court has acquired jurisdiction. And the ICC has acquired jurisdiction over the accused, former President Duterte. And if I go by the record of the court, it will proceed to hear the case all the way to trial and up to the moment of decision of whether to acquit or to convict him. So the two proceedings, those before the ICC at The Hague and those in Manila can move forward, fine. But I think in the end, in terms of the proceedings in Manila, I don't think a Philippine court is able to order the ICC to release a prisoner. I don't think a Philippine court is able to order the ICC to release a prisoner. I don't think a Philippine court is able to order the ICC to release a prisoner. The Rome Statute is designed really from the beginning, and I took part in the drafting of the statute, from the beginning to say that there is no such thing as head of state immunity, and that there is no immunity that attaches to the acts committed by, in this case, President Duterte at the time, even at the time when he was president. So,
in accordance with Article 61 of the Rome Statute, the court's founding treaty, and Rule 1211 of the Rules of Procedure and Evidence, the main purpose of this initial appearance is to answer 3 questions. Firstly, the Chamber must ensure that the person who was the subject of the arrest warrant has been informed of the crimes of which he is accused. Second, the Chamber must ensure that this person has been informed of his rights as recognized by the Rome Statute. Third, the Chamber must set a date on which it intends to hold a confirmation of charges hearing. The Chamber notes that your counsel, Mr. Duterte, filed 2 motions, one in relation with today's hearing. And you may be aware that these 2 motions have not been accepted by the Chamber because of the nature of today's hearing. No further discussion on the matter is necessary during this hearing because, as I said at an earlier stage, the aim of this hearing today is to introduce the parties and to ascertain the charges and to set a date for the confirmation of charges hearing at a later stage. With regard to the first point, I recall that Mr. Duterte has received a copy of the warrant for his arrest and that a redacted version of the prosecutor's application for the issuance of the warrant of arrest is public. We have come to the end of Mr. Duterte's first appearance hearing. I would like to thank all the participants in this hearing, the interpreters, and the stenographers. This concludes today's hearing.